Good afternoon, everyone. Welcome to the special City Council meeting for today's date, July 31st, 2025. And since this is a special meeting, there is no caucus to start with. We'll formally call this meeting to order, and please rise for the Pledge of Allegiance. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Now, this matter has been called into session as a result of a FOIL, Freedom of Information request. There was certain information that had been denied, and as a result, the complainant, and in this case the appellant, Monamusen, filed an appeal, and by our charter, the city council is the body to hear that appeal. And as a result of that, I will now turn this matter over to our city attorney.
We'll take roll call.
Oh, I'm sorry. Please, thank you.
Maflahe?
Present.
Anderson?
Here.
Moretti?
Here.
Sirdike's been excused. Morano?
Here.
Law Department?
Here. Thank you, Your Honor. So to reiterate, Mr. Musen had filed a Freedom of Information law request for certain items related to an application that he had made before the planning board. The city responded to the Freedom of Information law request on July 21st. With a couple days later, Mr. Musen filed a formal action or Article 78 proceeding in Supreme Court, naming the city as a respondent. There was, a number of items requested in the lawsuit, including, that the planning board take his matter, which had been tabled at the June 25th meeting, off the table and vote on his planning board or site plan approval, And in addition, in the lawsuit, Mr. Musen is requesting that the documents that were redacted in the city's response to the FOIL request be provided to him. So with respect to the FOIL response, Mr. Musen had requested a number of items, communications, and I laid those out for the council in my communication to you all earlier this week. Everything that Mr. Musen has requested has been turned over to him. He requested the planning board meeting minutes, a recording of the planning board meeting that happened on June 25th. He requested any communications from the other individual who he has some sort of personal dispute with, whose statement was read into the record at the planning board meeting. He requested any internal communications by the city or employees, officials, et cetera, of the city relative to his application before the planning board, so his site plan application. And he also requested any communications relative to a business sign that Mr. Musen had hung at the property prior to getting site plan approval and, prior to the business registration process, which I do not know where Mr. Musen, is with that process. Obviously, that process will commences or is the next step, and that will be before the council eventually. So as the city attorney, obviously I spoke with all the individuals involved with the situation and turned over everything that was responsive, with the exception of a handful of communications which were included in the response, but portions of which were redacted on the basis of attorney-client privilege. So just to be clear for the record, there were no documents or communications that were absolutely withheld when the city responded to Mr. Musen's FOIL request. And I apologize, Dean, because I hope you can hear me though. So nothing was withheld. There were portions of certain communications that were redacted on the basis of attorney-client privilege. And along with the response, as you all have likely seen, I did provide a privilege log, which is legally required, basically identifying the communication, identifying who was involved, the time, et cetera, and the basis for the redaction or withholding of the communication. So as it stands right now, every document or communication that was responsive was provided to Mr. Musen, with the exception of the redacted portions, which were redacted on the basis of attorney-client privilege.
So if I understand correctly, the only thing this body has to decide is whether or not the redacted portions of the communications should be disclosed.
I agree in part, Your Honor. It would be the city's position that the arbiter of whether or not the attorney-client privilege applies is really a function of a court of law, because it is a legal issue, whether or not attorney-client privilege applies. I would also say that there's an added layer in this instance because Mr. Musin has commenced a formal lawsuit against the city, and a significant component, or at least a claim in that lawsuit, is whether or not these documents were properly withheld on the basis of attorney-client privilege. So the court, will reach that question. So in this matter, there is an added layer because there is pending litigation, and the FOIL request or response to the FOIL request is really not an ancillary issue in the litigation. It's really one of the central issues in the litigation. So I would take the position that it really is the function of the court to be the arbiter of whether or not the attorney-client privilege applies because it is a legal issue. But to the extent the council wants additional information, as to the contents of the communication, my recommendation would be that the council would go into executive session because it would be potentially detrimental for the city for the public to be able to have access to those communications, given the pending lawsuit.
Okay, so the lawsuit though is directly related to the denial of the FOIL request.
In part.
In part. Can you
Yes.
explain what the other parts are?
Yes, so Mr. Musin filed an Article 78 proceeding, Councilmember Muflahi, and in that proceeding, he asked for what we call in the legal field as specific relief or for an injunction. He asked for and I'm gonna go off memory, and I do have the documents if I need them, I can reference the documents that Mr. Musin filed with the court. But what he requested was various forms of relief. I think part of it was having the planning board take his tabled site plan application off the table at the next meeting, which occurred on Tuesday. I think Mr. Musin requested that any information about him from the June 25th planning board meeting essentially be removed from the record or redacted from the record. Mr. Musin requested that any communications that were held to be privileged under the attorney-client privilege be given to him. He requested that if there was any documentation withheld on any other basis, that documentation be given to him. As I mentioned a few minutes ago, nothing was withheld other than what's redacted. I believe part of the application to the court had something to do with the communications between Mr. Musin and the city relative to the removal of the business sign that was at the property prior to the site plan approval. So the lawsuit is actually asking for what we call in the legal world as injunctive relief. So there was a hearing before Judge Koyakovo, who's a judge in Supreme Court, a couple of days ago. Mr. DeCesare, who's outside counsel for the city of Lackawanna and is defending the city in this matter, appeared. The court denied preliminary relief, which means immediate relief, but is allowing the city time to submit a written response as it relates to the ultimate relief that Mr. Musin is seeking. And the city will have the opportunity to do so. I think our papers are maybe due the 11th of August or something to that effect. So there were a number of items that Mr. Musin requested in his application to the court. The FOIL piece is one of the items that was requested.
Okay, so the matter before us today is to make a decision on whether or not it was rightfully denied. The FOIL request was rightfully denied. And our decision is based on whether or not client attorney privilege exists within the emails that you had forwarded over to us and also shared with Mr. Musin. So our determination is based on the redact files, which we are not privy to as well. So how can we make a decision based on the unknown?
Sure. So again, I think as I explained a few minutes ago, the code is extremely vague, the Lackawanna City Code, as it relates to this. And it's my understanding that the council hearing an appeal of a FOIL request is somewhat unprecedented, at least under these circumstances. So I think the code, is vague. And, if the council today decides that it is within their province under the code to have access to those communications, that is something that the council can decide. Again, from a legal standpoint, it's the opinion of the law department. That is a question for the court to decide. But if the council would like to ask specific questions or be provided specific information about what was redacted, we certainly can do so. But because there is pending litigation and because the redactions are potentially, at least this law department takes the position, they're covered by the attorney-client privilege. I would recommend that a discussion regarding the specifics of the contents of that communication be done in executive session, because they could potentially affect the city or be detrimental to the city in the litigation that's pending.
So the fact that the permit for the business license or the planning board passed and approved whatever it was had before it regarding this doesn't render that issue mute?
I don't think so, Your Honor. I think, the city would certainly take the position that because Mr. Muson's application has been passed by the planning board, that portion of the lawsuit, or that relief that Mr. Muson would be seeking, if he is still seeking that relief in the context of the formal lawsuit, that claim would be moot. But it does not moot the issue of whether or not the documents were withheld on the basis of attorney-client privilege or not.
But in order for us to make that decision today, I would argue that we would need to be privy to the contents of those emails, which I responded to your email requesting an unredacted, the unredacted files in order for us to make a thorough and sound decision today. Without that, I can't, and it would actually draw a negative inference if those documents were withheld in the redacted form.
A negative inference meaning what?
Meaning that I would have reason to believe that there isn't any client attorney privilege within those documents if it's not shared with us.
I don't see how you conclude that, but anyway, are there any other questions by the city council? If not, I'm going to make a motion that we enter into executive session for the purpose of addressing the portion of the appeal for the FOIL request that pertains strictly to the redacted portion of any communication between our law department and whomever on the basis of attorney-client privilege, and furthermore that on the basis of pending litigation. Furthermore, I would also, as part of my motion, ask the council to consider including Nicholas DeCesare as a party to the executive session, since he is now attorney of record of the lawsuit downtown. And part of my motion also will be that all council members surrender their phones so this matter does not surreptitiously be recorded against the confidentiality that's being requested. Is there a second?
I second.
Judge Morano,
Yes.
am I able to speak?
We can give you a few minutes to speak, sure.
I just a couple minutes.
Yeah, you're welcome to come up to the podium. I'm sorry?
Your Honor, may I just comment on the comment by the council member about the negative inference?
Oh, sure.
Yeah, I just wanted to make clear, I don't know why there would be any negative inference. As the city attorney, it is my sole responsibility to make sure that the city is absolutely protected, whether it's from litigation, to make sure that all ethical rules of conduct are being followed, et cetera. So I would think that it would demonstrate just that the council is relying on the legal opinion of the city attorney. I don't think there would be any negative inference, but I just wanted to make that clear for the record.
Yeah, but we have a decision.
We're not going to get into a debate.
Well,
No,
we
we're
have
not.
a decision to make, and I think that evidence is vital in our decision-making.
Yes,
It
and
absolutely
that can be
is.
part of the discussion.
Within
that-
executive order.
That when we go into executive session,
Agreed.
we're not going to debate negative inferences now. That's immaterial.
Right.
And it may be immaterial during the
Possibly.
regular session or the
Possibly,
executive session.
But having it
Okay.
present is.
We're gonna hold my motion. Mr. Musin, you're welcome to address the council.
I indeed, my name is Manu Musin. I'm the applicant for 2170 Abbott Road. I'm trying to open up a bookkeeping service for the community. I applied for a FOIL request, and I specifically asked for communication between Michaela Bone and her family with any city official. The response by the city attorney was attorney-client privilege. Michaela Bone is a third party, and to see that as a response
But
from...
Mr. Mearson, I don't mean to interrupt, but
Yes.
I don't agree with what you just said. That communication from the individual you mentioned was not declared to be privileged under attorney-client privilege.
In the response that I
no.
received from the city, it was. And
I looked at that, I didn't interpret it as being the case, and if I'm not mistaken, that communication was read as part of the proceedings before the planning board, correct?
there was also other communications that was withheld until my appeal, and it was just I asked for all communications, and I received it approximately 1 hour before showing up to Supreme Court. So approximately 1 hour, I had to file an appeal, and these were just communications between Michaela Bone and city officials. So that was very awkward that it was denied initially under the pretense of attorney-client privilege, which you could see the response. It's documented.
Okay.
And then later on, after the appeal, 1 hour prior to entering Judge Amelo's chambers, I received an email from the city attorney saying these are the remainder of emails that I didn't provide previously.
Well, given what you're asking for, any additional communications, if the city attorney denies any further communication or any documentation of communications, that's the end of our road. We are here this afternoon strictly to interpret whether or not the redacted portions of any documents that you did receive and that we were made aware of should in fact be redacted. And I would just caution you that there is a protective measure that is being claimed, that it's attorney-client privilege, which we will get into discussing amongst ourselves in executive session shortly. But do you want to add anything material at this point?
Yes, actually, I do. I'd like to add material, and I'd also like to debate that there was client-attorney privilege because the document that was received was made public. So on that basis, anything revolving around this.
But you just answered your own objection. If the document that was claimed to have attorney-client privilege was made public, there was no claim of attorney-client privilege.
But the communication around that document should also be public.
What communication?
Between city officials with each other. That's the main key. I want to know why this document was not shared and was kept in secrecy until the very last minute before the Development Board Committee was going to vote. This was an ambush. This document was an ambush. And it was not a part of the agenda. It wasn't shared to the people that matter most is the people who are voting. And it was not even shared by Director Charles Clark with his own committee.
Okay, and I can't speak to that, but if the communication was eventually shared, then that's not something for us to discuss today. I'm sorry you went through what you went through, but that's not the point of this meeting today. And we are not going to rehash the entire argument. We are here strictly to talk about the redacted portion.
I understand. Your Honor, if I can pass out this is a barcode. I would like each member to scan this barcode. There's very vital information. It's on a Google Drive. That's what this is.
We'll be glad to accept whatever you want to hand out.
This is from a Dr. Clark, who in 2019 made similar allegations against me regarding, I don't want to go and say it, but very similar accusations. I've only uploaded one video and a doctor summary of Dr. Clark and what she said. The video shows the moments before an exchange with my children in this building, the Lackawanna Police Station, and immediately after the children were taken to this Dr. Clark, and these reports were made about me. But if you watch the video and you look at the reports, you're gonna see that there's something wrong. Now, I'm not accusing Dr. Clark and Charles Clark as co-inspiring just based on their last name. But I believe this deserves investigation by City Council to see if there is any relationship between Dr. Charles Clark and Dr. Catherine Clark.
We appreciate that, and we'll check that as best as we can with the resources we do have. But, and Mr. Mushin, you also understand that since you do have pending litigation, no matter what we decide here today, that issue is still before the court.
I understand that.
So, you know, it's still alive.
And the main relief that I'm looking for is that the judge declared that Charles Clark was in violation by introducing this letter in secrecy. So that is my main relief that I'm seeking, but attorney did not bring that.
And you do know that we can't judge that.
No, I just wanted you to be aware of that.
We appreciate that, thank you.
Thank you.
Okay. All right, then, proceed with my motion was seconded by Councilmember Moretti.
Moved by Morano, second by Moretti to move into executive session. Maflahe?
Yes.
Anderson?
Yes.
Moretti?
Yes.
Morano?
Yes.
Carried 4-0. Time is 1:51 PM. And please clear the courtroom, the chambers.
Yeah, since we're going in executive session, we do that privately. The courtroom or the council chambers needs to be clear.
It's 2:24 PM.
Okay, but before you do that, for everyone's information, we have just concluded our executive session. And to that end, I make a motion that we return to our regular session of the special meeting for the Lackawanna City Council.
Second, ready?
Motion by Morano, second by Moretti to return to our regular session of the city council meeting. Maflahe?
Yes.
Anderson?
Yes.
Moretti?
Yes.
Morano?
Yes,
Carried 4-0.
and what's the time?
2:24.
Thank you. Unless there's any further discussion to be made or a motion, I will make a motion based on the information before this council and the ability for this council to review the redacted information, and given that the majority of the information requested by the FOIL request has been turned over to the complainant, the remaining portion under redaction and based on attorney-client privilege, the fact that there is pending litigation, and finally, the fact that there is ongoing oversight by a superior court where the action is pending, that the motion to appeal be denied.
Does it die on the floor for a lack of second?
No, a second.
She's waiting for.
Okay. Motion by Morano, second by Moretti, based on the attorney-client privilege and pending litigation, ongoing oversight by the Superior Court where action is pending, the appeal be denied. Let me see if I get that right.
That's not quite what I said.
I did my best here. Based on attorney-client privilege and pending litigation, as well as ongoing oversight by the Superior Court, where action is, oversight by the Superior Court where action is also pending, that the appeal by Mr. Michon should be.
Let me,
Okay, go ahead.
without objection to the council, I'll reword.
Please.
I move that the request for the appeal be denied. Based on the attorney-client privilege comma, pending litigation and continuing review by a New York State Superior Court. Can you read that, babe?
Yes. Motion by Morano, second by Moretti, that the requested appeal be denied based on the attorney-client privilege, comma, pending litigation and continuous review by a New York State Supreme Court.
It's close enough. Yeah,
Maflahe?
No.
Anderson?
Yes.
Moretti?
Yes.
Morano?
yes.
Carried 3-1.
Okay, that concludes this meeting. I move to adjourn.
Second.
Motion by Morano, second by Maflahe to adjourn meeting. Maflahe?
Yes.
Anderson?
Yes.
Moretti?
Yes.
Morano?
Yes.
Carried 4-0.
Thank you, everyone.